Hey, welcome to the Life and Legacy Show, sponsored by the Seckler Law Firm, where great families make great estate plans. My name is Tim Seckler. I am your host on this radio show. If you're new to it, we do this show each and every week, and the idea is giving you the information I think you need to know to make great estate planning decisions. I own a law firm in Cranberry Township called the Seckler Law Firm, where we focus predominantly on doing estate planning for folks. We also have an elder law practice, which allows us to help people plan for and get the care they need, particularly in their senior years. And we have become a very much education based law firm where we provide our clients with tons and tons of education before we ask them to make a lot of technical legal decisions because this stuff is complicated, and it has always been my opinion that it is better to go ahead and provide the education rather than force some clients into a decision they don't really understand. And so I put a lot of content out there in the world. You can find well over 100 episodes of this radio show linked to my website. You can also find the old episodes on Apple iTunes or Spotify if you're looking for them. And we put out tons and tons of information from the standpoint of once families understand their options, they're likely to make good decisions. And we want to help you make good decisions. And so the way that you work with my law firm, if you're interested in learning more, is we offer free estate planning workshops, which we do around town. You can find them all at secklerlawfirm.com. That's my last name, Tim Seckler. So that is hard to spell. My first name, Tim, is not. So you can go to estateplantim.com. It'll redirect you to the website. You can find all of our upcoming workshops and register. They are free. Takes about an hour and 15 minutes. And what we do is we try to take these estate planning concepts and put them into some stories to help you understand them. It's really a good workshop, and people tend to learn a lot. We get really high marks. So I hope you can join us at one of our upcoming estate plan workshops. And so what I'm going to be chatting about this afternoon, in today's episode rather, is the things that result in estate planning failures. Okay, so what are the top 10 reasons that estate plans fail? And my intention is to do this in a 2-episode series this weekend and next weekend on the top 10 reasons that estate plans fail. And it's not just going to be that the documents have bad provisions and that kind of stuff in it. It's going to be the other stuff around the plan, failure to communicate, and estate plans that are not funded and whatnot. And so we're going to go through these things. And the idea here is whether you have done an estate plan recently or not, maybe you're thinking about doing one in the future. What I want to do is talk to you about that plan, and whether we wrote the plan or someone else wrote the plan, maybe you find something here that ends up saving you from making a mistake. And so let's get into it. So the top 10 reasons that estate plans fail. Number one on the list, and these are in no particular order other than the reasons, the experiences that I've had, we came up with a list, but is that the estate plans are too simple. All right. So there's this thing that happens in the world when you meet with financial advisors, or if you meet with an attorney and you tell them you want to do a thing where estate planners will say, well, look, I've reviewed your situation. You're in your first marriage, and things aren't all that complicated in your family, and you're not rich, and so let's just do a simple will. And you're not rich, so let's not overthink it. And I got to tell you, I think that is a fundamental mistake in the way that attorneys are advising their clients. And the reason for that is really this: life's not simple. Your life is not simple. The laws governing how this stuff works, if you get sick and when you pass away, are not simple. And so it's really difficult to put you into some simple box, even if things on their face seem simple. And I'll give you an example. If somebody ends up, the will, when we ask clients about estate plan, one of the questions I ask in our workshops is, tell me the first document that you think about when I say the words estate plan, right? And most people say the will, right? Okay. But what's a will really do? A will really answers the question, who gets my stuff when I pass away, right? Which makes two assumptions. One, you're going to pass away and this is still your document. Two, when you pass away, you still have some stuff, right? Because the will only deals with your stuff at the time you pass away. But what about all the things that could get in your way between now and the time you pass away? What if you unfortunately become disabled? What happens if you need long-term care? What happens if you sell your house? What are the tax implications of that? Is there some tax savvy moves that we can do to save some money during our lives? What are the different things that we can do now to protect assets, protect your stuff from long-term care expenses, and the like? And so, this is, to me, one of the reasons estate plans fail is that, quite simply, the documents are too simple, the plan is too simple, and you were essentially sold some document rather than a real solution. And I personally believe that attorneys should not be in the document business. We should be in the solution business, and oftentimes the solution requires some more complicated planning. So one is, it's just too simple. I went in and it's like ordering a sandwich at Subway. I want ham and cheese. I get ham and cheese. You go to a lawyer's office and say, I need a will. Well, wait a second. Let's talk about the problems you're trying to solve first, and then we'll get to whether that's a good solution. Second reason that I think estate plans fail is that the estate plan is not well funded, or we could say not well coordinated. All right. So there's this underlying mistake that people make, that, let's say it's a will estate plan. Okay. Well, the will governs the assets that you own in your own name. But lots of people own assets jointly, or lots of people own assets that are beneficiary designated. Consider your retirement account, your 401k or your IRA. That account has a beneficiary designation on it. That account is, generally speaking, not governed by the terms of your will, but people think that it is, right? And so people will come to the office and they will say, I want it to go equal shares to the kids, except I want 20% to go to this nonprofit first. And they think that they're setting up a document that's going to govern all of their assets. The reality is, it doesn't govern all of their assets, because it doesn't govern assets that are either jointly owned or assets that have beneficiary designations on them. And most middle class families have beneficiary designated assets. They do, right? So, if you have a retirement account, that, generally speaking, is going to be governed by a beneficiary designation, not your will. And so we need to make sure that the beneficiary designations on that account match, or at least align with, what the will is purporting to do, so that we're actually planning for all of your assets when you pass away, not just your house that you own in your own name. Okay, so a lot of the time it's not well coordinated between the attorney, the law firm that did your will, and your financial products. The other is, there's trusts are becoming more and more popular as estate planning tools. I happen to really, really like the use of trusts. We advise clients to use trusts pretty frequently. But a trust, once you create a trust, you can think of a trust kind of like you might think of a company. So, the secular law firm is the company that I own. It owns some stuff. It owns a laptop. It owns some desks. It owns some stuff. If you create a trust, it's kind of like that. You create this legal entity. You got to put some stuff in the trust. And to put stuff in the trust, that means funding the trust, changing ownership of various accounts to be owned by the trust. And if we want the estate plan to work correctly, then we've got to actually get assets into the trust. Otherwise, it's not going to work. And so oftentimes there's this thing that occurs where people will spend the money to have a trust, and then fail to put anything in it. They get some letter from the law firm that says, hey, by the way, you need to fund your trust. Clients don't really know what that means. And so then they never put anything in the trust. Now, trusts are great tools when used correctly. You got to fund the trust. So not funded or not coordinated is another reason why estate plans will fail. Another thing is, and this is a thing that really would be easy to solve if anybody took the time to do it, is that, people will do an estate plan, and they will name their family members, or their adult children, usually if you have kids, to be to have certain roles in the estate plan. My son Joey's going to be my executor. My daughter Susie's going to be my healthcare directive, my healthcare agent. Bob is going to be my power of attorney. And then you don't tell them, and you don't share the documents with them, and the kids don't know that they're named in the documents. And if the kids do know they're named in the documents, they don't know what the heck it means, right? If I would take a survey, let's say that I'm working with a client who's 70 years old, and so then maybe the kids are in their 40s. If I took a poll of the average 40-year-old across this country and asked them a simple question, what does a trustee do? What do you think the answer would be? Do you think they know? Do you think they even know what it is? What does an executor do? That's a more common term. People kind of know the term executor. What's the power of attorney? What's the agent under the power of attorney do? What do they do? And these people have no idea. So then what happens is mom or dad own the smart, or name the smartest kid or the local kid to be the agent under the power of attorney, to be the executor under the will, and they're going to name Joey. But then they don't tell Joey, and even if they did tell Joey, um, they don't. Joey doesn't even know what the heck it means to be a power of attorney. What are you asking me to do? I don't understand what you're asking me to do. And so, one of the reasons that estate plans will commonly fail is because your kids don't know their roles and responsibilities. This is why in our law firm, one of the things that we do is we have a quarterly webinar for our clients' kids, teaching them this terminology. Here's what a trust is. Here's what a trustee is supposed to do. If dad passes away, if dad gets sick, you call us. Here's how you work with a lawyer through this process. And so we've taken the position that it makes sense. Estate planning is not just writing some document. Estate plan is a relationship, and estate planning is, when done properly, at least the way I see the world, when done properly, is a commitment to a successful future. It's a commitment to, I don't have to lose sleep over this anymore. I don't have to stress out that my kids are gonna fight, and I don't have to stress out that I'm putting a big burden on my kids to do some confusing thing, because my law firm works with you to teach your kids their future roles and responsibilities to eliminate this stress. And that, to me, is just part of good planning. Now, most law firms don't do that. It's kind of a system that we made up around here because we kept seeing stressed out kids, family members who didn't know their role and responsibility, frankly, didn't want to take on the role and responsibility, felt obligated to do so, but then realized that it's a couple hundred hours of work, and I don't really have the bandwidth to do this. And so we want your family to understand what's up against. And these are the types of issues I shared at the top of the hour, that we are an estate planning law firm, but we're an education first law firm. We do classes. I and or my team are teaching classes monthly on these topics to our clients, because I want your estate plan to work the day that we write it. I also want your estate plan to work 5 years from now and 15 years from now. And that needs to reflect the reality that estate planning, when done properly, is a process to be managed rather than a transaction, right? I can't tell you how many times clients have come to the office and they've got some document from 20 years ago that some lawyer wrote. They can't remember the lawyer's name. They're pretty sure he or she's retired. And they've got this document. They don't really understand what it does, right? Well, what kind of a plan is that? It's like somebody coming to let's say somebody goes to a travel agent and just comes in with a map, right? Well, there's a map to a location, but this was where you wanted to go 20 years ago. Is it still where you want to go? And is this even the correct route anymore? Maybe they've built a new highway, which in our world means maybe the laws have changed. Maybe your family dynamics have changed. Maybe your goals have changed. You don't want it to go to this person. You've got new family members in your life. You've lost family members from your life. And so estate planning, guys, it's called planning. It's a process, and we got to check in on it every year and make sure that it still works, because you can't plan for tomorrow with yesterday's documents. Tomorrow's needs and tomorrow's potential issues need to be planned with tomorrow's documents, and so we've got to keep the thing updated if it's going to work correctly. And these are the types of concepts that we teach at our workshop. The estate planning seminar that we invite you to is called The 3 Secrets to Protect Your Legacy. We have them upcoming around Pittsburgh, North Hills. We have in South Point coming up. Couple locations. You can find them all. Just go to estateplantim.com. That'll redirect you to the Secular Law Firm website. where you can go to the workshops tab, find the upcoming workshops, register. It's free. The workshop's about an hour and a half. And during the hour and a half, we teach you these concepts. We teach you the difference between a power of attorney and a will. We teach you the difference between when would I want to use a will-based estate plan? When would I want to use a trust-based estate plan? What's the difference between a revocable trust and an irrevocable trust? And why might I want to use one rather than the other? How do these things actually work, right? And because, all the time we talk to people about estate planning, and all the time people tell us, oh, I need to do that. Oh, I need to do that. Oh, but why haven't you yet? And the answer is because this stuff, generally speaking, is not fun to think about. This stuff is not exciting, right? But it is necessary. It's kind of like, in a way, look, we estate planners, we know that we rank somewhere between going to the dentist and getting an oil change and, I don't know, buying a new car, right? Like, it's not an exciting process to go deal with a car salesman. It is an exciting process to get a new car, but I don't really want to do the thing first. I don't want to go to the dentist. I go to the dentist because I know that if I don't go to the dentist, my teeth will hurt. Well, it's kind of like that with estate planning, except it's not so palpable, right? You need to go to the estate planner. If you don't go to the estate planner, ugly things happen, but it's not so immediate, and I can always put that off till tomorrow. And so that's why we offer these estate planning workshops rather than just telling you to come in for a free consultation, because I want you to understand what you're up against before you decide whether this is actually a thing you want to do. But what I'm concerned about is that there's so many families out there with their heads in the sand, just saying, "Oh, I'll do it tomorrow. I'll do it tomorrow. I'll do it tomorrow." Well, you know what? A lot of families end up in our office and it's tomorrow and something has happened. Somebody's sick, somebody's injured, somebody's hurt, somebody passed away. And there was no plan put in place because the person who's now sick or passed away was going to do it tomorrow. And so, there's no easier way that I know how to do it than to get you to a low pressure group session where we can teach you all the things that you need to know in order to make a good decision, and then we talk about how best to do this. So that's a little bit about our process and why we do it that way. So we're working through the list of why estate plans fail. The next reason I want to discuss is that the estate plan does not incorporate a plan for long-term care. Right? So this to me is the reason I started my law firm is because one of my family members, my grandfather, ended up losing his entire fortune to Alzheimer's disease. He ended up in a nursing home. He ended up going through $6,000-7,000 a month for a number of years until the money went away. And he had an estate plan. The estate plan did not give any consideration to what would happen if he got sick. From my perspective, the threat of long-term care, the threat of the expense of long-term care is the biggest financial threat that most retirees are going to face. If I end up in a nursing home, the state of Pennsylvania will tell you that nursing homes cost $13,000 a month, 13 grand a month. That's today's dollars, right? What about 10 years from now, 15 years from now? What's it going to be? $20,000 a month, $25,000 a month? I mean, these are incredible numbers. These are terrifying numbers. And according to the Alzheimer's Association, 1 in 3 of us are going to have dementia. So if 1 in 3 of us are going to need dementia, most studies say 2 out of 3 people, seniors, will need some form of long-term care. 1 in 3 are going to have dementia. 2 or 3 are going to need some form of long-term care. Nursing homes are $160,000 a year. And some lawyer told me all I need to do is answer the question, who gets my stuff when I pass away? Right? We don't want to have a conversation about asset protection. Like, what if we could teach you a way to protect your house from these expenses? What if I could teach you a way to protect your money from the risk of the nursing home? Wouldn't that be a thing you would want to know about? But so many people's estate plans fail to answer the question, what happens if I get sick? How do I know that my wife is still going to have a house to live in? How do I know that my wife is still going to have some money in the bank? How do I know that my kids will eventually receive an inheritance? I am not interested in working for 50 or 60 years to save a nest egg, to lose the entire nest egg to long-term care expenses. Not in my plan. Not part of how I want to spend my time on this planet. Definitely not the way I want to exit this planet. broke and giving it all to some healthcare system. I'm way more interested in understanding how I can get the care that I will eventually need without going broke in the process, so that there's actually something left from my nest egg to pass on and improve the lives of my children. Not a complicated goal. Most people would agree with that goal. So then, if most people would agree with that goal, why is the most common estate planning document a will? Because wills don't answer that question. Wills answer the question, what happens with your stuff when you pass away, right? Which assumes there's still some stuff when you pass away and you didn't lose it all to long-term care expenses. That's my philosophy in estate planning. It may not be your philosophy in estate planning. If it's not your philosophy, I'm probably not your lawyer. But if the things that I'm saying make sense to you, then you ought to attend one of our workshops. We teach you great concepts at these workshops, and you're going to learn how to use an effective estate planning tool like a trust to protect your house, protect some money from these expenses, and live a more peaceful retirement, knowing that you're not going to go broke due to long-term care expenses. That's kind of the idea. All right. I want to get in one more before we end the show, and that is that estate plans are, generally speaking, not updated frequently enough. Right. I meet a lot of families who come to the office, and when they come to the office, they're retired or thinking about retiring, and the documents that they bring in, generally a will and a power of attorney, they're brown. They've yellowed over time, and the executor named in the will passed away 12 years ago, and the other person that we named, we kind of lost touch with that person. Why did we choose that person again? Oh yeah, the kids were little. We couldn't rely on the kids yet. So now it's probably time that we can rely on the kids. But Johnny's in Michigan, and Susie's down the street. But Susie's been making some questionable decisions recently. And this is a family I'm describing that probably should have updated their estate plan about 5 times over the last 2 decades. Things have happened. Their life has changed, let alone the fact that the law has changed. Their priorities have changed. They're now older than they were. They're not, families with little kids are predominantly worried about answering the question, who's going to take care of my kids? And is there going to be enough money for my kids if we pass away young? But as people become empty nesters and they start sliding towards retirement years and they ultimately do retire, the question is not about how do we take care of minor children anymore. The question is, how do we enjoy our retirement in a stress-free approach? The question is, how do I make sure that we don't go broke? The question is, how do we do this from a tax efficient standpoint? Now that I'm in the final quarter of my life, from a year standpoint, how do I make sure that I make tax savvy decisions so that my kids don't get smoked by the IRS or by the Department of Revenue? So the goals change. And the law changes. There was a major change in the law in 2020. It was voted upon in 2019, became effective January 1st of 2020, that impacts your retirement accounts. Most people don't know about it. It was called the Secure Act. The Secure Act changed the way that your IRA, when you pass away, if you have an IRA or a 401k, the Secure Act changed the way that those funds need to be distributed. It expedited the way that those funds are going to be distributed. In effect, what it resulted in is, in my opinion, a death tax on the middle class, because it used to be the case prior to Secure that if my dad left me a retirement account when he passes away, I could take that money over my life expectancy, which, depending on how old he is when he passes away and how old I am, assuming I'm still here, it could be 20, 30 years tax deferred growth on the money, which is beautiful. So they took it away. And now what happens if somebody passes away with an IRA? In most situations, that money needs to be distributed from the IRA within 10 years after the parent passes away, which expedites it expedites the time period that the money needs to be distributed, which means that we have to take it in a shorter period of time. Remember, this is ordinary income, so that's going to bump us up in tax brackets. The second thing is, if my dad passes away and I'm in my 50s, well, most people in their 50s are still working, right? And so if I'm still working in my 50s, I'm already in an inflated tax bracket. On the old model, before the Secure Act, I could have taken dad's IRA money after I retired. I could have just sat on it and take it out after I retired. Now I got to take it out during my working years, and I'm already going to be in an inflated tax bracket. I'm going to get smoked on the money, right? So I just bring up the Secure Act. We've done other episodes on the Secure Act. That's not this episode, but I bring it up as a major change in estate planning. It's a major change in the law that impacts how you want your plan to be distributed, it could impact who gets what. Like, for example, if this is ordinary income and I've got a kid who doesn't make a ton of money and I've got a kid who is a neurosurgeon making $500,000 a year, well, maybe I want the money that's ordinary income to not go to the person in the highest possible tax bracket. Maybe we send some IRA dollars to the other kid that's in lower income, and we send some other asset to the kid in the higher income tax bracket, right? So this is a change in the law that arguably could change the way you want your estate plan to be handled, but you probably haven't given any consideration to that because your estate plan hasn't been updated frequently enough. These are the types of conversations that we try to keep our clients apprised of, because I look at estate planning. In our law firm, our clients are not transactions. I'm not trying to sell you some document. I want a relationship with you that will continue to help you today and tomorrow, because I want the thing to work, and that's the best way to do it. So these were the top 5 reasons that estate plans fail. Next week's episode, we're going to do reasons 6 through 10 on why estate plans fail. So I look forward to seeing you there. Remember, this show is for your education and information. Don't make any legal decisions based on what you hear on this or any other radio show. If you need legal help, we're here to help anytime. Go to estateplantim.com and we'll help you out. See you next week.